Good evening, everybody. You'll be pleased to hear that I already slurped my tea during that countdown, so I won't have to subject you to that this evening. Welcome to another special live stream on Moving Home with Charlie, with me, Charlie Lambden, and my guest this evening, Simon David from Thomas Legal, a conveyancing company that I work with. Simon's just waiting in the wings. Before I bring him in, I just wanted to remind everybody that, especially if you are a seller, your choice of conveyancer is almost as important as your choice of estate agent. I mean, almost as important as your choice of estate agent. But in this market, in this challenging market, you should choose your conveyancer first to get yourself contract ready with a firm that's not going to try and tilt you one way or the other, and then choose your agent. So when you talk to agents, you can say, I've already got a conveyancer and I'm coming to the market contract ready, which will meet the estate agent's requirements for displaying material information on your property and will demonstrate to sellers that you are serious about selling your property. And so, demonstrate to buyers, I mean. So for serious buyers out there, a serious buyer wants a certain transaction as much as a serious seller does. And so if they can buy your home faster than, so they can buy your home in 1 or 2 months rather than 5 or 6 months, as is typical now, you're more likely to attract those serious buyers to your property if you can market your property as contract ready. Now, I've said this many times. I don't see much evidence of it happening out there. I know a few people are doing it, but you really need to ask yourself, if you're not willing to come to the market contract ready, are you serious about selling, or are you just dipping your toe in the water? Because that's what buyers are going to think. And if you are serious about selling, there's no better way of showing it than by being contract ready. So go and choose a conveyancer very carefully first. And when you talk to them, ask them, how do I get contract ready? Now, without further ado, let me bring Simon. Otherwise, I'll end up rambling on for minutes. Good evening, Simon. How are you? Welcome back.
Yeah, I'm very good, Charlie. Hope you're good.
Yeah, not too bad. Thank you. Not too bad. So yes, you probably heard everything I just said about being contract ready. And a question I'd like to kick off with for you is, do you or your team ever get involved in being asked by movers to recommend an agent? And if a mover does decide to follow my suggestion and get their conveyancer first before they choose their agent, and the conveyancer recommends an agent, I mean, as someone who's worn both hats as an agent and a conveyancer, I always say it depends on how well you trust the person that's giving you the recommendation as to whether you should take it or not. And what's your view on that?
Yeah, I think actually it's up to the client to make that decision. What I generally would do is say, I would look on Rightmove. I'd look at the people, I'd look at the agents within the area that are dominant. And I'd pick the top 3 because they're probably the ones that sell most property. And I'd say, get them round, meet them, have a chat with them. And actually choose the one that you feel more comfortable with, because I might feel more comfortable with Joe Blogs, but someone else might be, more comfortable with another agent. And I think a lot of it comes down to personality. I've just come back from a networking event. And that's why I'm looking so smart tonight, Charlie. And unlike yourself. And
listen, as we speak,
yes,
SpaceX is putting a lunar module on the surface of the moon. They've successfully done the launch, and I'm a massive fan. And it's the child in me one day hopes to go to the moon. So that's why I'm wearing this tonight, because as we record this, which is live, as we have this live stream, it's up there right now, putting something on the moon. That's why I'm wearing this tonight. But,
that's cool. That's cool. You're much cooler than I am. So yeah, I mean, I was at a networking event, and it was very interesting. I met a few agents, and clearly there's always people, like in your private life, that you get on with rather than other people. So I'd recommend people to get 2 or 3 round. And as you've said before, don't choose the one that gives you the highest price just to get it on the market. Choose the one that you feel comfortable with and you think is going to give you the best service.
Yeah. Okay. Right. We do have some advanced questions, but because, as you know, and the viewers don't, I was a little bit flustered and rushed getting started this evening. I'm going to start with this one on the screen from Teddy B. And then I'm going to look for the other advanced questions. So Teddy B on YouTube says, is it a good idea to rely on a search pack that a seller may have recently bought, or should you get your own copy, i.e. what are the risks of accepting the seller's search pack?
I think you'll usually find that a search pack will be, although it may have been obtained by the seller, you can still rely on it. And you can get your solicitor to check that or check it with the search company. And as long as you can rely on it, I see absolutely no reason why you couldn't accept the results of those search results. It's going to save you time at the end of the day. And as I said, if you can rely on it legally, it's a bit like a survey, isn't it? You get a survey carried out by maybe by the previous buyer. And you might be able to buy that survey from the surveyor, and as long as the surveyor says yes, you can rely on it, then I don't see a problem with that. So it's going to save you some money as well, probably, if you can get a search pack if the seller's not going to charge you for that. So yeah, absolutely.
If I'd known he was going to say this, I wouldn't have answered his question. Teddy Bees is then followed up with, "That's it, Simon. Give him some stick and perhaps a razor."
Yes. You see, I'm professional. Had a shave, smell nice.
Right. Oh, I just had a shower before this, so I'm not smelling terrible either. Okay, so this was the first advanced question that we got. It was actually a question that came on YouTube. I can't get up on screen. I'm not that well organized, but there is the question I'm about to read, everybody, right? Which is from East of the Danube on YouTube, who asks, "Could you do a video about suing a seller? Under the Consumer Protection Against Unfair Trading Regulations Act 2013, under which sellers are required to tell the buyer anything that might affect their decision to buy the property, even if the buyer doesn't ask about it, it is no longer a case of buyer beware. I'm considering suing my seller because having just moved in, my circumstances have changed and I need to move ASAP. Since I will be honest to prospective buyers, unlike the seller, I will lose close to 40 grand, which the seller will be compensating me for. The more cases brought to court, the more transparent buying and selling a house will become, and the cheaper the houses will be, as no one wants to say drive straight into a parking dispute or live next door to someone with an ASBO. It's disgusting that so few people have a moral compass and are willing to lie just for 30 pieces of silver, but it was ever thus." So yes, advice about suing a seller. So I suppose the question is, are there ever legitimate grounds for a buyer to sue a seller?
Yeah, absolutely. Misrepresentation is a classic one. Have they misrepresented the position to you? I mean, I don't know if I told you this story about the classic one where the buyer and seller got very friendly during the transaction on Facebook, became Facebook friends. And then the buyer moved in, property flooded within a few months, and the seller hadn't said there was any problem with flooding ever. And then they looked back at the seller's old photos on Facebook, and sure enough, there was a picture of them standing in their wellies in a couple of feet of water a few years ago. Classic example, misrepresentation, lied basically, and of course you've got a claim against the seller for that sort of position. I'm not a dispute specialist, but yes, if there has been what we would call a material omission, i.e. they should have told you something, maybe if it's not covered in the questions that the sellers fill in, but there was something quite fundamental about the property that they should have told you about, then yes, you could sue them. Suing people is expensive. If there's been a few sofas left in the house and you move in and you get very irate about it and go, I'm going to sue the seller because they didn't move the sofas out, it's likely to cost you a lot of money to get someone into court, when actually in that position where you had a few sofas, actually all you need to do is get a skip in and move them out, and that's a pain in the backside, and you should get the money back from the seller for that. But ultimately, getting people into court, suing them is expensive. It really is costly
and time-consuming.
And so time-consuming. We know the courts are way behind on this sort of thing. You could be waiting years. It causes you stress and anxiety. I know it's horrible. I've moved into a house myself where there was lots of stuff left. The point about misrepresentation is an interesting one. I think we covered it last time. In the questions that the seller fills in the form, there's one particularly which talks about, has there been any dispute with a neighbor, for example? But the key is about the property. So just because you've got a difficult neighbor next door as a seller, you don't have to disclose that. Someone, I don't know, they've got a noisy dog or whatever, but it doesn't affect the property. So it's got to affect the property. If you've had a dispute about the boundary, yes, it's got to be disclosed. We don't know enough background about that particular scenario. Did they lie about parking space? Did they lie about something else? And yes, you've got to prove it. It's going to be expensive. It's going to be stressful. I feel for people, and it does happen. Sellers do lie, sadly.
Okay. Zara Olibocus on X, who I think is a fellow conveyancer, says if you
Good
have
shit,
legal
yeah.
expenses insurance under your building insurance, contact them. Yeah, would you agree with that? Like, use your insurance to cover lawyers' fees if you've got
Yeah,
that.
potentially,
Yeah,
if it covers that, yeah.
yeah,
Not
yeah.
all
Okay.
insurance policies will cover it.
I would also, just before we got so many questions coming in, they're really great questions. I wanted to just make sure, because I have been known to forget in the past, that everybody knows, because I've got a lot of new followers, which is fantastic. Everyone knows that Simon runs the conveyancing business, Thomas Legal, which is my one and only hand-picked conveyancing partner. So for those of you who cannot find a conveyancer you trust, or haven't got time to find a conveyancer you trust, and you come to me through my website, it is Simon's firm who you will be dealing with. And if you'd like to find him or his firm, down there, mhwc.co.uk/conveyancing. Link should be in the description below as well. I'll make sure afterwards that it is if it's not there now. But just to make sure. So that's one of the reasons that Simon is here, because we work together effectively. And so far, it's been nothing but harmony and happiness, and everyone's been happy and come back. And
I like the way you say "so far."
well, never say never. You got
No, I
you
know.
always get the occasional one, don't you? But so far, I can hand on heart. So far, not a single bit of feedback of complaint or unhappiness at all. And it's that's not an easy thing to achieve.
Right.
So anyway, right now back to the questions. The next question I've actually got is on my phone, because it was an advanced question. But I've got to get back to the. Sorry. This is because I haven't got a producer. You see, I need a producer. I'm just going to leave that on the screen for now. Right. The next question is from Elite Alex on YouTube, who asked an advanced question saying, first time buyer, buying with partner, not married. I'm putting in all the deposit, which is a decent chunk. We will split the monthly mortgage payments. In terms of protecting myself, should the relationship break down, I know pre-marriage we can get a deed of trust set up to say how the equity should be split should the worst happen. What happens post-marriage? I understand that the deed of trust is not really worth that much in that scenario. I've read a prenuptial agreement also isn't really worth much to protect in a divorce either. So what can I do to protect my money again if the worst should happen? Does buying as tenants in common with different percentages afford any protection?
Well, Alex, clearly you're getting married, so you love that person. So therefore, you should not worry about this problem. If only
I
that
think he's being very, very pragmatic, because the stats aren't great.
No,
It's like 50-50 pretty much. So I think he's being pretty
they're
pragmatic.
not great. We're sort of coming into matrimonial problems. And actually, I knew that was an advanced call. And I rang my sister-in-law, who's a brilliant matrimonial lawyer, before the call. And she sort of confirmed what I thought. So first of all, do the declaration of trust, the deed of trust, which is a document which sets out your interest in the property, which says you've put in this, you've put in X. In the case of splitting up, then you will get your money back and you'll split the proceeds X, in a 50-50 or whatever shares you want. Although you'll be married, and then something called the matrimonial clauses act will sort of take precedence over everything, the courts will generally, my understanding is that they will still look at a declaration of trust. Now, if you've been married for 6 months or a year and you split up, then it is more likely they're going to look at the declaration of trust. If you've been together for 35 years and you've had, 3 children, and, that's a completely different story, and they're going to not take any notice of it. And the prenups, for those of you that don't know, are prenuptial agreements, very much an American format. So people would disclose wealth and agree what would happen in the event of a split up. From a monetary point of view, they are becoming more. They're not binding on the English courts, but they are being looked at by the English courts. So I think if in that position, all you can do is you do a declaration of trust and you do a prenup. If you're not getting married, you can do a declaration of trust, and you can also do a living together agreement, which is a bit more detailed about how you're going to live your lives and as cohabitees. So that could be something to think about as well.
Okay, fantastic. Thank you very much. Next advanced question was from James Sky on YouTube. I think we've had this one before, but it's a regular one, so it's worth asking again. In the event of a sale fall through or /chain breakdown, is there a way to cover for conveyancing fees such as some kind of insurance. I think he's a seller.
Yeah, there is insurance. There are insurance policies out there, not many, and they tend to be quite expensive, and they're also limited in the cover that they offer as well. So I think the average conveyancing fees are between £1,000 and £2,000. It might cost you £300-400 to cover that. We did look at it. We did a bit of a pilot scheme with clients a while back, and there was very little take up, because people, sadly, as you know, Charlie, don't like spending money up front when it comes to this sort of thing. It comes to sellers, paying up front for searches. And you've talked a lot about being move ready and contract ready. It's very difficult to actually get money out of people because they don't think it's going to go wrong. They're feeling very positive about it. They're thinking, I'm going to exchange contracts in a couple of weeks. And you go, well, would you like to buy an insurance policy just in case it all goes wrong? They go, oh, no, it's all fine. I met the seller. We've had a beer together and it's all great. And we're going to move together. Yes, they are around. You can Google them. There are policies around there, but they tend to be quite expensive, I think.
I mean, it's a great point you make, and I just wonder, as someone who does a fair few transactions every month through your business, can you give an off the top of your head sort of breakdown of the most common reasons for transactions falling through? Is it people once they're pulling out, or is it one of those things that's like an involuntary failure where actually something arises that stops the transaction? I've no idea.
I mean, it's everything. It might be survey, it might be mortgage, it might be change of circumstances. At the moment, I think buyers are a little bit more fickle because there's so much more choice on the market than there has been. So we are seeing people that will, change horses without really thinking too much about it. And I think that this all comes down, as you and I have been banging on about for ages, getting yourself ready, getting this deal done, getting it through as quickly as possible so no one can change their mind, or another property comes on the market and suddenly your buyer goes, oh, hello, that looks quite nice, I might go and buy that instead. So yeah,
this is where I think you and I are totally in agreement with this. I cannot say it often enough to people. Speeding up the transaction also increases the chance of it going through and not failing. It's a direct correlation. The faster the transaction happens, the higher the chance of it succeeding, the lower the chance of falling through. And yet, especially first time buyers and sellers just won't move very quickly. Like, you need to, it's in your own interest. If you want that transaction to happen, get off your ass and make it happen and get your paperwork and get cracking, because the longer you wait, the higher the chance of you incurring costs because it's fallen through.
Yeah. The best one I had was the fall through was the client who rang me in and said, I've bought this house, I'm buying this house. It's £1.5 million. And he said he'd entered into the Canadian lottery and won the money. And I said, oh, that's great. Have you got proof of that? And he said, well, I don't think I have, but I've been told I'm getting the money shortly. And I said, well, did you actually enter the lottery? Well, I'm not sure I did. My wife may have done it. Of course, it was one of these scams. And the poor old agent had obviously accepted his offer, and that was a fall through. That didn't really go very far, that one. But quite how the agent ever agreed the deal in the first place is beyond me. But
well, I have to say, I've heard lots of stories in this market, an awful lot of non-proceedable offers being made.
A lot. There are a lot, I can tell you that. Yeah, absolutely right. And in fact, I'm selling my house at the moment, and a lot of the people looking at my house are not proceedable. In fact, we had one today, and the agent said, I don't really know if she can afford it, but they'd like to look at it, and I'm thinking, right, okay, well, that's very interesting. But, this is what people are like. They'll say, well, yes, I'm sure I can afford it. But actually, when it comes down to it, they haven't done a mortgage application. They haven't checked their position financially. And this has been going on for years, that people are like this, sadly.
Now, by the way, everybody, I've got one more advanced question. And if you put in an advanced question, I guarantee to do advanced questions first. So always remember that, because we've already got too many questions to get through in this show already. So it's fantastic. But I am going to start going through the questions that you've put in now. But one more question from Whipper Will, or S. Hardy. Yeah. We've sold twice in England over the last 2 years, got close to completion on each, only to break down both times for various reasons. It's been agony, and both times incurred some legal costs without any recompense, so I was told. Do we have rights here? Is it legal to ask for a deposit? So someone else again, is suffering from fall throughs.
Yeah, no, good question. And yes, you can. You can do, I think we may have covered this last time, you can enter into something called an exclusivity agreement or a lockout agreement. Not very common in this country, but you can do it. So if you're a seller or buyer, you can ask the person on the other side to enter into an exclusivity agreement with you. At that stage, that will then probably give you a period of time to get to exchange of contracts. And if you don't, and a sum of money is paid there as a if you like, a deposit which the solicitors hold, it's usually £5,000 or £10,000, something like that. If you fail to exchange contracts within the period that's set down in the agreement, then the seller, it'll usually be the seller, would get to keep that money.
Right.
So that is possible. The trouble is they're not very well known. And in this market, which is a difficult market, buyers are not prepared to enter into them. In a very, very busy market where it's a seller's market and the seller's got 15 buyers all want to buy the property, absolutely go for an exclusivity agreement. Say to the seller, I want exclusivity on this for a period of time. Yes, more common in London as well. Sadly, but where the buyers tend to be more savvy about buying and selling property, and you're talking about much higher value property. So they do happen. Exclusivity agreements, worth talking about.
Right, now on to the questions from this evening's live guests and viewers. Tasmanian Devil says, if an incident of criminal damage, i.e. broken window, weeks before exchange, is this something I'm obligated to disclose to the buyer?
That's a good question. I think if it's not actually covered, I don't think there's nothing in criminal damage covered in the property information forms. So strictly speaking, I would say you wouldn't have to disclose it, because I would think if you think about how many people have been broken into over the years in their property, sadly, there's nothing in the forms which says you have to disclose that you've been broken into. However, obviously you need to fix the window or disclose that the window is broken. But I don't think there's anything legally that you'd have to disclose in relation to criminal damage.
Okay. Right. Next question. Kylo Hawk asks, if a property looks like it has If a property looks like it has damp issues and you flag it as a concern, but the buyer assures, I think you mean the seller assures you it's fine, is it reasonable to suggest a price negotiation if it shows up in the searches?
Okay, well, it won't show up in the searches. It'll show up by your surveyor going round to have a look at the property. Remember, as we've talked about before, when you apply for a mortgage, the bank or building society will only send round a surveyor just to check that the property, what they call, represents adequate security. In other words, does it stand? Does it look okay? Is the valuation okay? They're going to be there maybe 10 minutes, 15 minutes. If you're not borrowing very much money, they might not even look at it at all. They might just do what's called a desktop valuation, check it exists on Google Earth, and happy days. The reason that you should get a survey every single time is for your own benefit, to check things like damp. And if there is damp shown up, the surveyor will say you should get specialist reports. You get a specialist report, and absolutely you should go back to the seller and say, I never realized it was damp. I need to renegotiate the price. However, if the agent at the time that you viewed and you made your offer said, bear in mind this property is cheap because it's got damp, then don't think you can go back and try and get some money off the second time.
Yeah. Okay, great. Next question from Alfredo on YouTube, who asks, what checks are necessary to establish a cash buyer is not laundering cash, and how long does it take?
Yeah, well, we've talked about this, I think, before. Well, how long does it take? Well, it depends on where the cash has come from. If it's very straightforward that the cash has come from an inheritance, we would be saying to the client, well, can we just see evidence of that inheritance? It could be a letter from a solicitor saying what the estate was worth and what your share was, and we can see it going into your account. That might be done in a couple of days. However, if you say, well, I've actually made this cash out of the sale of shares, and then I invested in a mine in deepest, darkest Africa or something like that, then well, clearly that's going to take longer to establish that we're comfortable with the source of that wealth. So I don't think I can say how long does it take. It might be very quick. It can take weeks to establish wealth, because remember that we're on the hook for this as lawyers.
Yeah.
We are the front line for money laundering prevention. And if we get it wrong and we allow this money to wash through our accounts, which is criminal money, then we're on the hook. And PC Plod will come along and say, you're off to Nick, my sonny boy, because you haven't actually done what you're supposed to have done and check the source of funds and the source of wealth.
I think it's very few people actually understand that as lawyers, you guys are on the hook if you let dodgy money through. That's a good question.
We've had 3 this last month in relation, particularly, I'm just going off subject a little bit, which involve cryptocurrency. And
question is on this.
Yeah, and it is going to become more of a problem for lawyers. Very challenging for lawyers to be comfortable with crypto.
Well, can I put the next question up? Because I think that
of course, absolutely.
Anton says funds invested in Bitcoin blocked when buying source of funds. Can't just disregard money we have worked hard for and saved, ? How to verify these funds that lawyers want to just ignore? I think his sentence structure is a bit confusing there, but I think what he's saying is, this is money I've worked for. I've then invested it and saved it. I've saved up my money. Why is it just being ignored? And how can we verify it so that it doesn't get ignored? So I think that's what you were just talking about. You've had that come up 3 times, have you?
Yeah, and it's becoming more of them because more and more people are investing in crypto. I don't actually call it investing as such, but people are putting money into crypto.
Punting.
Punting, including a couple in my own firm, actually. But it is going to become more mainstream. We do have a solution for crypto, and we do have an expert, not within the business, but an external expert who will look at source of the crypto and how it's come through, and what money's been made of it. It hasn't been invested in the dark web and all that sort of thing that probably you and I don't understand. And we will take a view depending on the amount. But a lot of lawyers, as soon as you mention crypto, absolutely will say, absolutely not. It's not coming past our desk. There's too much risk. Okay. We recognise it's an issue for clients, but we do have a solution.
Cool. Okay, you heard it here, guys. So Simon's firm can handle it as long as you've got your proper paper trail for your. I mean, Simon, I don't know if you know this. I bought crypto, a tiny amount of Bitcoin, in 2017. It's now worth about 100 grand, and I can't find it.
Oh, you're like that bloke who's got that stick, isn't he? And he said to the council he'd share the millions with them. He's worth about 20 million or something.
Yeah, it's not that much. It is only about 100. I punted 200 quid, but really early on, and it just went. And I and annoyingly, I bet you I find it when I don't need it anymore. One day.
Your house looks a bit messy. Have you had a good look route around those at the back?
Honestly, quite regular. I've even spoken to a company that helps you find lost Bitcoin, but there are a lot of hoops to jump through. Anyway, next question. Tina B asks, if I get you lined up as my conveyancer, then apply for a mortgage, how can I know you're on my lender's panel? And if you're not, what then?
Yeah, so it's a good question. Most decent conveyancers will be on all the panels. If you're not sure, you would just ask us. Okay. I mean, we're on, I think, virtually every lender panel. There'll be maybe some obscure ones that we're not on, but no, we're on all the major ones. And then any conveyancer that's decent should tell you. And if they're not on there, they should tell you up front, because you don't want to be instructing a conveyancer and then have another conveyancer acting for the mortgage lender, because that's going to cost you a lot of money.
Yeah, exactly. Okay, it's a good question. A Tasmanian Devil again asks, if a new build development has a road leading to it, which has part owned by a private dwelling, which is part owned, the road is all made up to that part that is owned and then is unmade, is this an issue?
There's quite a lot in that. I think you'd be looking at the legal documentation, making sure you've got adequate rights over the road, whichever part of the road it is. If you're looking at a property, and when we talked about flats last time, and we're talking about the communal areas being a bit rubbish, and that tells you quite a lot about the development. But if you're going into a private development, let's say there's 5 houses and it's a driveway up there, and half the driveway is great and the half is rubbish, that tells you quite a lot about the development. So I think your solicitor will be having to ask some very pertinent questions as to who actually owns this road. Is it that they all contribute towards the cost? and how much have they been paying, and is there a company that owns it? Are they all got shares in the company, and who's actually responsible for maintaining it? It sounds like a bit of a mess to me, but it's very difficult to know the answer to that without looking at all the legal documentation.
Right. Yeah. Okay.
But yes, I'd be thinking there is a problem there.
We've got loads of good questions still coming in. And actually, I've got one for you, Simon, which is a question. In fact, someone actually, I think, has answered the question already. Oh, yes. Zara has asked, does Thomas Legal deal with Building Safety Act properties?
Yes, we do.
Can you explain what that is and what it means and why she might be asking the question?
Yeah, Building Safety Act. Building Safety Act came out this year, so last year, in relation to, which has all come from the very, very sad events at Grenfell. And it's trying to deal with the obligations between landlords and tenants, if you like, owners of blocks and flat owners, who's responsible particularly for the safety of that building, generally around cladding, and what your obligations are, how much a landlord or a block owner can charge you, etc., etc. It's a terrible piece of legislation. It's insanely complicated. Most conveyancers have said, not interested, I'm out. I'm absolutely not interested in doing this sort of work, particularly in high rise. That's where it's most common. And there's all sorts of regulations about it. It applies to properties which are over sort of 5 stories height, or there's a particular meterage. But then there's properties where it's exempted from it. It's absolutely right that it's there because we don't ever want a recurrence of what sadly happened, but it's terribly drafted. So during the conveyancing process, there's all sorts of certification that has to be obtained by the lawyers. Lawyers don't understand it. Clients don't understand it. Our reports in relation to Building Safety Act properties are very, very long indeed. As I said, most lawyers, and even some lawyers' own insurers, have said, you are not able to deal with this work because it's too high risk. The way I look at it, and we've got experts within the firm that deal with it, the way I look at it is people need advice. And there are people that still want to buy properties where there is cladding, or not necessarily cladding, but they're affected by the Building Safety Act. And they must have a solution. I've always thought this, where we have a particular piece of legislation that comes out, we always want to be at the forefront and say, we can deal with this, we understand it, and we will help you through it.
Fantastic. Okay, cool. I'm glad we got that question, because we had a BSA question last time that we missed.
Yeah, and it's particularly London and big conurbations, Manchester, lots of Building Safety Act, and London as well.
Quick one here. I know we had this similar last time, but do you have to disclose noise complaints against neighbours?
Well, I think you'd look at why there was a noise complaint made. Is it just that they've been having a few parties? Is it because their dog's noisy? So I come back to this, the answer I gave a bit earlier. Does it affect the property? Just because they're, they like getting drunk with their mates and being a bit rowdy in the garden, in the hot tub, I think that's slightly different to, is there a noise issue because they keep banging on the walls, or is that affecting the property? Do you know what I mean? It's a tricky one, noise complaints. And also it's quite subjective. What I might think is noisy is you might not think is noisy at all. I mean, you'd be a nightmare neighbour. You've got a bloody drum kit in the background. I mean, I feel for your neighbours.
As a new build, this house is like airtight and soundproof. It's incredible.
Yeah. You get on with your neighbours?
Yeah, well, my neighbours. Then I have. It's okay. I mean, I'm on a building site, and I can almost reach out and touch the digging machinery that's out, the heavy earth-moving machinery. So my drums get drowned out by the sound of the heavy machinery outside during the daytime. So
yeah, but you play your drums at night, Charlie, whenever it annoys everyone.
I don't. I have a sleeping baby in this house. Can you imagine? My other half would batter me if I touched the drums and the baby's asleep. Okay, right. Lots of questions. I just want to get through as many as we can. Imran Rashid on YouTube says, should buyers give sellers a questionnaire to try to tease out potential problems with the house. So I think, on top of the already questionnaires,
Yeah.
if a buyer's got questions like, I've been to view it and I've got some questions about here that aren't covered in the form.
Yeah. So the sellers fill out a very complex, very detailed form about legal aspects relating to the property. If there are practical things or practical problems that you as a buyer have identified, but they're not legal, then you need to direct those via the estate agent. So, but I'm a great believer in going to talk to the sellers directly. I think it's great to have a relationship with sellers. If you have a relationship with them, then if there's another one person in the wings and you're worried about losing the house, if you've got a relationship with them, it's less likely that you're going to lose the house. I like talking to people directly. So if there's a problem on your survey, you can go and talk to them directly, because if you speak via the agent, then sometimes it's lost in translation. So I'd go and talk to them directly or talk to the agent. If there are legal problems, then you just ask your lawyer to raise those as questions, which your lawyer will, of course, do on your behalf. If the surveying questions, so you have your survey and it says it's damp or whatever, then again, that will go back through the agent, because that's not a legal question.
Okay. Next one. I think this is probably a bit more of it's a mixed question, but it's a great one. Wayne's Retro World on YouTube says, if I wanted to be contract ready as a seller, should I get a mortgage in principle in preparation for the next house? And if so, how to go about doing this? I would say, first of all, talk to your mortgage broker about getting the mortgage in principle ready for your next. It's nothing to do with being contract ready for your house you're selling, is it? But it's
correct.
But it's getting your ducks in a row. Absolutely right.
Yeah, as much as work as you can do up front, do it, both from the selling point of view and from the buying point of view. Yeah. You get contract ready on your sale, you get an offer. The day you've got an offer, you can go and view properties, or you may have already viewed properties, and you can go and say, I'm also mortgage ready on the purchase. It's just going to save time. We were talking about saving time before, and that's what it's all about, getting this deal through as quick as you can.
Yeah. Now the next question is from someone who I know who's been really struggling to sell because of a right of way issue and has had at least one, if not more, deals fall through where the buyers pulled out when they discovered there's a right of way. But this is new information. So Daisy Chains to Buttercups on YouTube says, I've been trying to sell my home for over a year because of the right of way. Now just had a letter from the council to say the house next door proposal to be turned into a children's home. So that's obviously something brand new that's come along, and I suppose this isn't so much of a legal question as actually the poor seller. She just wants to sell, and it seems like the universe is turning against her a bit there. But maybe as a former agent with your hat on, like, what do you do with a seller who's just getting peppered with these problems?
Yeah, very sad, and I do feel for you. It is a question which is dealt with on the property information form. It says, have you received any notices or correspondence from the local authority, I think, about this property or a property nearby? Well, clearly that would fall into that category, and you'd have to disclose it. And sadly, yes, it is going to put off a lot of people because of noise, and maybe these children have problems. I don't know, but yes, I really feel for you. That's really
I would say that if you don't think the agent you've got is a fantastic agent, I'd start to talk to some other agents, and you'll usually find an agent that's been around for a long time and really knows their stuff, and will actually be frank and honest with you about saying, listen, because of these things, if you want to get sold, this is what you're going to have to do with your property. And if you don't feel that your current agent is being proactive enough, I would talk to other agents, is what I would do.
Yeah, and you may have to wait until it becomes a children's home, and then it's clear to people. You don't have to disclose it then, because it is a children's home already.
Graham says, if a solicitor fails to address a boundary issue despite having 4 years to do so, and this then causes a sale to fall through, can I claim for the losses that will be incurred?
That's a very broad question. I don't really know enough about it to be able to answer it clearly. I quite why a solicitor's failed for 4 years. That sounds like it's a dispute. It's not a conveyancing claim. Causes a sale to go through. So I guess you've been in dispute maybe with your neighbour or something like that. It causes a sale to go through, but have you had a buyer sitting there for 4 years? And you're going to claim against this? Well, you can always claim against a solicitor if there's been professional negligence. Of course you can. And in that scenario, I think what I do is, you're very patient to wait 4 years. If you think the solicitor should have done it very quickly, I'd be going and getting some third-party legal advice and potentially claiming against that solicitor if you feel they haven't adequately represented your interests and have failed you in some way. So there's always that ability to do that.
Okay. Thanks. I know that was a tricky one, but thank you for taking that question.
Right.
Let's keep you on your toes.
Yeah.
Property Ladder on YouTube says, I understand most UK new build freehold houses now have completely unregulated, uncapped estate charges in the TP1. Are buyers fully aware of the risk of such estate charges rising?
Yeah, so there was legislation relatively recently where new builds can only be freehold rather than leasehold. If you remember, there was all these new builds that become leaseholds and escalating ground rents, and there is lots of consultation going on in relation to ground rents and estate charges and all that sort of thing. There is a TP1 is basically a transfer of parts. So when you buy a new build, you're buying a little bit of the estate legal title. I'm not going to get it's complicated. In there may be an obligation for you to contribute towards the estate as a whole. It could be that the estate's got parking areas or something like that, and you will have to contribute the estate charges. It is up to your solicitor to basically make sure that there is a mechanism in place to either limit those charges or to put your notice if they increase or whatever. So I think this is down to your solicitor to advise you. There's nothing wrong with estate charges, because clearly if you live on a very nice estate and there's, the communal grass is mown and the parking spaces are all kept nice and tidy and everything else, well, that's brilliant, because it's horrible to go to an estate where it's scruffy and quite rightly you should contribute towards the communal areas. The problem is if there's some sort of uncapped amount and it becomes very expensive for everyone, then that could cause problems when you sell the property. So it's very important to get legal advice, and your lawyer checks things like the estate charges.
Okay. Mark says, what happens if the freeholder won't complete an LPE1 giving details about ground rent? That's an interesting question.
So when you buy a flat, you buy a lease generally, which decreases over the time. And there is a set of questions which go to the landlord, i.e. the owner of the block, or maybe the managing agents, the people that look after the block on the landlord's behalf. It's called an LPE1. And it talks about things like, can we have a receipt for the last ground rent paid? Can we have a receipt for the service charge paid? Are there any plans for expenditures of the block that we need to know about? Have you served notices on the owners of the flats to say what you're planning to do, and have they agreed this cost? All that sort of thing. It's really good information. If they won't complete the form, well, you're buying a property blind, and your solicitor will say, well, if you have a mortgage, then I can't go any further until I've got this information, because the mortgage provider will say, we're relying on you as our solicitor, because remember, the solicitor's acting for the lender as well as the buyer. We'll rely on you to provide us with this information so that we can confirm it's adequate security. If you're a cash buyer, you could decide, well, I'm not really bothered. If the freeholder will not complete the LP1, what the hell does that tell you about the development, about the block and about the freeholder? I mean, I would stay well clear of that.
Right. Yeah. Because you're just rolling the dice, aren't you? Otherwise,
you're rolling the dice.
You're just taking a massive count.
You complete, and then you find out actually that the landlord's planning, £1 million worth of work to the block, and you're liable for X% of it.
I came across a situation like this recently, and I just think if you've got any grey areas like that, there shouldn't be grey areas, but they are grey areas. It's always a red flag. It's always a red flag. And given that there's more and more choice of property on the market now, find a property that hasn't got red flags about it, as in unanswered questions. You can get good value properties if the issues are disclosed and there's no grey area and you know exactly what you're buying. But when you're not sure and you're like, oh, it's fine, they tell you it's fine and don't worry about it. I wouldn't. Okay, next one. So it's a slightly tricky question. Really struggling to find a conveyancer who will work on a first floor flat in a 5-story block. Some have told me they will work on it, but don't quote it in the fees, and I don't want to get stung later. I'm not sure if that's...
I think this is coming back to Building Safety Act, because if it's 5 stories, it may be affected by the Building Safety Act. Okay. Well, you need to make sure that you speak to a solicitor who has expertise in the Building Safety Act. There will be additional fees if it's applicable. But as I said a bit earlier, just because it's high rise or over 5 stories doesn't necessarily mean it's affected by the Act. So in that scenario, the solicitor shouldn't charge you any extra fees. If it is affected by the Act, it is highly likely, because they're going to be involved in a lot of extra documentation, they will charge you fees. Solicitors have to charge you, have to quote it to you. They can't up front. They can't just send you a bill at the end and go, oh, I want another £2,000. It'll get thrown out by the regulator. They're not allowed to do that. They must confirm in writing what the fee is, and you must agree it, and then it will be charged later on.
Okay. Hugo Page on YouTube says, can you get a completion date before mortgage offer to hurry up a slow lender? As they say, if you have a completion date, they will fast track. Don't know if that's a question for you or not, but
I think it's probably one for a mortgage advisor. But you can't have the only way you can get a completion date that's actually agreed is if you've exchanged contracts.
Yeah, okay.
But you won't have had a mortgage offer if you.
Yeah. Okay, so answer I think is probably no, Hugo. Is that one?
Yeah, no. And you could, and I think of course you can put pressure on the lender, or your mortgage advisor can put pressure on the lender saying, we need this mortgage offer out. Our client needs to move in by such a date. But I don't think you can do any more than that.
Okay. Tasmanian Devil again asks a question that actually I'm quite keen to get your answer on, because I answered this the other day for someone. The developer is pushing for me to use their conveyancer as well, alarm bells. Now, my view is that I would have they might be a perfectly legitimate, trustworthy, respectable conveyancing firm who do a totally legitimate job for the developer. But also, I know of relationships that are not healthy, where said conveyancer will get so much work from that developer that they will occasionally help transactions through that another conveyancer might raise more questions about. So I tend to say, unless there's a very compelling reason to go with the seller's conveyancer as the buyer, or the seller's recommended conveyancer as the buyer, I would always choose your conveyancer yourself, based on what you need and the relationship you want and how responsive they are to your questions. You want a conveyancer that you know is working for you and is not indirectly working for the seller of the property. That's my view. But as a conveyancer, I mean, you I suppose you must do some work for developers as well.
Yes, I think the question is actually the developer is recommending a different conveyancer, not their own conveyancer, because the same person can't act for buyer and seller.
That's right.
So there will be times, and I do get it, where a developer will work with a particular solicitor that is really good at new build work. New build legal work is mountains of paperwork again. It's lots more than you in a general second-hand transaction. There are solicitors out there, and I know there are some, I live in the Southwest, there are particular lawyers that I know really good at new build and do loads of it because they understand it. And what they do is they say to the developer, look, we will do a deal for your buying clients because we'll look at the estate as a whole before we've even transacted any properties. We'll do our report because we know that every single property is exactly the same. We've just got to change the name and change the plot number and look at their mortgage offer. And the benefit to the buyers is that they will get usually discounted rates. So if you go to a lawyer who has never done any properties on that particular development, they are likely to charge you quite a lot of money because it's a new build and they've got to wade through all this paperwork. If you go to a solicitor that's done 14 of the same development, it's sausage machine. They haven't really got to think about it. They should be charging you a lot less. And I'd be asking that question of them, saying, have you done any others on this development? And in which case, I want a discount on your fees. So I think there is advantages to doing it sometimes. My own stepdaughter did it. We were really up against it on her. We had a sale and she just agreed to buy a property, shared ownership, new build. And I said to her, ask the developer, is there any solicitors locally that have dealt with those properties? And sure enough, there was, and we got it through in 2 weeks. Now, my firm could never have done that.
I see.
So
I'm really glad I answered the question because that's a different perspective I hadn't considered. So thank you very much. And that's a very helpful answer. Really cool. Okay, next one. MJ says, I have been moving my deposit money around different savings accounts, chasing the ones that would offer the best interest. Is this going to be an issue when buying a property?
No, as long as you can prove, MJ, those payments and show those payments made, and you can confirm why you can show that's been just down to interest. But remember, as I said before, solicitors don't just look at source of funds, i.e. which account they're in, and they'll look back at the other accounts, but they're going to look at your source of wealth. all very well moving your money around. How did you acquire that money in the first place? And that is the crucial point as far as a solicitor is concerned. And that's where you have to make sure you've got your ducks in a row.
Fantastic. Okay. Next one is from NB on X, who says, as a best guess, how long can it take to staircase a lease? And I think he also said it was from 70% to 100% was this particular.
Shared ownership. This relates to shared ownership. And shared ownership, for those of you that don't know what it means, what you can sometimes do, and again, I'll come back to my stepdaughter who did this, is brilliant, in that you can, usually with new developments, you can buy 25% of the property or 50% of the property or 75% of the property. And what that means is that you pay, let's say, £100,000 for 25%. So the flat's worth, and let's say it's flat in London, it's worth 400,000. You pay 100,000 for 25%. You get a mortgage for 100,000. You pay your mortgage payments on 100,000. The rest of it is owned by a housing association or a local authority, and you pay them rent on the other share. And that, believe it or not, can often be cheaper than you renting a room in London. That was my stepdaughter. She was renting a room in Shoreditch. I think it was costing her 900 quid. We found her a brand new shared ownership property in Walthamstow where she works. And she paid, I think, about £100,000. And overall, with the rent, the service charge and the mortgage, it was about 750. And since they've now traded up and they've now got another shared ownership, she's now got married. So they've got a bigger shared ownership flat. It's a brilliant way. If you haven't looked at this, then you should look at it. Staircasing is under the shared ownership lease that you'll sign. You have the ability to buy extra shares in the property, which is great. So usually there's a minimum that you can buy, and it's called staircasing. So you might go from 25% to 50%. You might have come into some money, so you've saved some money. So you can quite often get to 100%. Some leases don't allow you to do that, and then you get to 100%. How long does it take to do it? Well, it will depend on the housing association or the local authority and the paperwork. It shouldn't take more than a month or two to do it. Sadly, though, local authorities, being local authorities, do take a little bit of time to come back.
And when you say a little bit, you mean a lot. Right. Okay. Dan Bedford says, if someone has saved up a big deposit, 100 grand or more, just from saving hard while living with parents over 15 to 20 years, how would the conveyancer look at this?
That's great. I mean, no problem. That's what lots of people do. We've just got to look at it and look at source of wealth. And we will look at, if we can, a pattern of savings. We might not be able to go back 15, 20 years, but we'll look at a savings plan for the last few years. Does it look genuine? Remember, the larger the sums, the more likely we are to look at what we call enhanced due diligence to see, is there any risk in relation to these big funds coming to us? So it's not a problem. You just got to prove it.
Can I ask you a question? I mean, you deal with, you're a pretty decent sized firm. You deal with quite a lot of transactions. How often do you come across buyers where you just see the source of funds and you just go, no, definitely not. Sorry, no way. Does that happen?
Yeah, of course it does.
Right.
Yeah. I'll just tell you a story. We had a great one who had lots of cash purchases go. We asked for his copy of his account and source of funds and that sort of thing, and all we could see in his account just said pharmacy, sort of £50, £1,000, pharmacy, and we reported this person to the National Crime Agency, and because we were a bit unsure about it, and then ceased acting. And then we got a knock from the police a few years later, and of course it turned out the pharmacy was drugs, and he was a drug dealer, putting cash sums into his bank account. So yes, we've had less so. I would think it's probably like difficult to put a number on it, 2 or 3%. I would think, where we have really major concerns about funds. And it's usually the red flags where you have the very pushy client, large sums of cash, overseas money, weird sort of complications in relation to that cash. You can't speak to the client. There's a pressure on us to complete it quickly, all those big warning signs. So yeah, I think we've had 3 this last few weeks. Very, very interesting source of funds that we can continue with. Yeah.
And it's just worth reminding all the viewers, if you encounter something that you think does look suspicious, you are legally required to report it. And if you don't, you're in trouble, right? It's like, if in doubt, you have to say, yeah, this is a problem.
And we can't tell them we've reported them to the National Crime Agency, because that would be tipping off. So we have to keep quiet about that. And then the National Crime Agency have 2 weeks to come back to us and give us consent to proceed. That's all very well. That protects us from a criminal element, but from a regulatory side of things, we might still not be able to proceed because we're not satisfied with that source of funds.
Okay. I mean, through my relationships with London estate agents doing very, very high value overseas transactions, literally tens of millions or sometimes, and they'll do it in a week. These guys, they get it done in a week, but that must be interesting having for the conveyancer having to approve.
You can do them in days. We can do them in days. I think I've talked about this before. I think the quickest one we did was 48 hours, but the source of funds was so clear and it wasn't a problem. Right. Even though it was a very large, substantial purchase. But it's.
Here's a question that might be a bit tricky. Not sure. If a conveyancer didn't identify an issue with the lease at the time I had bought, and it's not compatible with lender's criteria, are they responsible for addressing it? A ground rent defaulting clause.
Well, as I said earlier, if your solicitors have been professionally negligent, then you have the opportunity to either complain to the legal ombudsman, who will look at it and give you some compensation. But if it's a negligence claim, then I would suggest that you seek third-party legal advice if that solicitor will not look at it and sort it out for you, because professional negligence is, sadly, they've clearly missed it, and they would need to pay you any loss of value because of it. So it's a professional negligence or claim, or it's a complaint to Leo, the legal ombudsman.
Okay, right. And just time for one more question. XR2828 says, "How can I be contract ready as a seller and buyer when I've not accepted an offer and not found a property to move to? I've got rough ballpark quotes from a few firms, but not instructed anyone." So I suppose the answer is you've got to instruct someone, haven't you? To actually be contract ready as a seller.
Well, I think we talked about this before. How can I be contract ready as a seller? Well, as a buyer, you got to treat the two separately. How can I be contract ready as a seller? You instruct a solicitor now. They do all the bits and pieces. They do your ID. They get the forms done. They instruct the searches. That's how you become contract ready. As a buyer, the same solicitor. You tell them where all your money's coming from. If you're putting money in and it's not just coming from the sale of your house, you go to your mortgage advisor, you get your mortgage approved in principle, an AIP, what do they call it? DIP, decision in principle, agreement in principle. You get all this work done up front for you. But you, as Charlie quite rightly says, you've got to instruct a solicitor.
Yeah. Okay, fantastic. Well, that was another great one, another great set of questions this evening.
Really good questions.
Just going to wrap up with, and I'm sorry I didn't get to all of them, but wrap up and say, if you'd like to talk to Simon's team at Thomas Legal, mhwc.co.uk/conveyancing, I always say, go and choose your own conveyancer that you're happy with the choice. But if you can't find you're happy with, or you haven't got time, then please do come and talk to Simon's team, because they really are outstanding, first-class guys. Thank you, everyone. Thank you, Simon, again. Anything you want to add before you go? Any more insults you want to throw at me?
No, market's busy. Things are happening, Charlie. Spring is coming. I see the crocuses were out today. It's all good. Let's be a bit positive. It's warm outside. The days are getting longer. Let's all be positive.
That's very nice. That is.
We were in recession. We're out of recession. It's all good.
Oh yeah, apparently on the news this evening, it'll all be over in a couple of months, according to Faisal Islam. A couple of months. So there we are.
Jobs are good.
All brilliant. Everything's good. Jobs are good. Exactly. Thanks very much, Simon. Thank you, everyone else, for watching, and I'll see you on the next one. Bye, guys.